9. Performance of contract. Section 37 prescribes parties to a contract must either perform or offer to perform their respective promises unless such performance is dispensed with or excused under the provisions of Contract Act. Hence, as per provisions mentioned in Section 37, a contract may be performed in either of the two ways. First, by performing promises, that is, by actual performance. Or, second, by offer to perform promise, that is, by tender of performance or attempt to perform. First, actual performance. Contract is said to have been actually performed when parties to a contract have done or have not done what they had undertaken to do or not to do, and no obligation remains unfulfilled under the contract, just like executed contract. Second, offer to perform or tender of performance or attempted performance. It means offer to perform the obligation by one party to other party. A valid tender to performance of goods amounts to actual performance, except in the case of tender of money. Tender of money is the exception to the rule that offer to perform will be treated as performance if all the conditions of valid offer to perform is satisfied. In tender of money, first, the debtor is not discharged from the obligation to pay the amount. Second, the debtor is discharged from his liability for payment of interest from the date of the tender of money. Rules for a valid tender of performance. First, performance should be unconditional. Second, performance should be of whole obligation. Third, performance should be at proper time if it is fixed by contract. Fourth, performance should be at right place as defined in the contract or otherwise fixed by the promise. Fifth, promisee should be given a reasonable time to ascertain that the goods tendered are in accordance with the promise made. Sixth, should be made to appropriate an authorized person. Persons entitled for performance in contract. Following persons are required to perform their part of obligation in a contract. First, promiser himself. Section 40. If it appears from the nature of the contract that it was the intention of the parties that any promise contained in it should be performed by promiser himself, or if the contract is of such a nature that it requires personal skills of the promiser, then in both the cases such promise must be performed by the promiser himself. Second, legal representative. In case of death of promiser before performance, his representatives are liable to perform the promise unless a contrary intention appears from the contract, except Section 40. Third, authorized agent. If Section 40 is not attracted. Fourth, third person. Section 41 clarifies that if promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promiser. Fifth, joint promiser. Joint promisers are liable for the performance of the contract jointly or severally by any of them. Performance of joint promises. When two or more persons jointly promise to perform a contract, they are known as joint promisers. The rule of performance of joint liabilities are as follows. According to Section 42, when two or more persons have made a joint promise, the transfer of joint liability will be in the following order unless a contrary intention appears from the contract. First, all joint promisers must fulfill the promise during their joint lives. Second, after the death of any of them, his legal representative jointly with the surviving joint promiser or promisers must fulfill the promise. Third, after the death of last surviving promiser, The representative of all promisors jointly must fulfill the promise to the extent of the estate derived from the deceased joint promisor. Section 43 explains the following points. The promisee may, in the absence of express agreement to the contrary, compel any one or more of such joint promisors to perform the whole promise. Each promisor may compel contribution. Each of two or more joint promisors may compel every other joint promisor to contribute equally with himself to the performance of the promise, unless a contrary intention appears from the contract. Sharing of loss by default or deficiency in contribution. If any one of the two or more joint promisors make default in such contribution, the remaining joint promisors must bear the loss arising from such default in equal shares. Effect of release of joint promisor. Section 44. Release of one of the joint promisors by the promisee does not discharge the other joint promisor or promisors from the liability, and their liability continues as before. Persons entitled to demand performance. First, the promisee himself. Generally, the promisee himself is entitled to demand performance of a promise made under a contract. Second, the third person. According to the doctrine of privity of contract, however, in certain exceptional case, a stranger or a third person to a contract can sue and can be sued under the contract. Third, legal representatives. In case of death of the promisee, the legal representatives of the deceased promisee can demand performance of the promise, except contracts involving personal skills. Fourth, any one of the joint promisees. Rules governing the decision as to time, place, and manner of performance of promise, where time, place, and manner are not fixed in the contract. Section 46 to Section 50. First, where no application by parties is to be made and no time is specified, in such a case, the contract must be performed within a reasonable time. The question of reasonable time is question of fact, which will be decided on the basis of facts and circumstances of each case. Section 46. Second, where the time is specified but no application by the parties is to be made, in such a case, the promisor may perform the promise at any time during the usual hours of business on such specified day. The place of performance will be the place at which the promise is ought to be performed as per the terms of contract. Section 47. Third, where the day is specified but the application by the promisee is to be made. In such a case, the promisee is under a duty to apply for performance at proper place and within the usual hours of business on such specified day. The question what is proper time and place is, in particular case, a question of fact. Section 48. Fourth, where no place is fixed and no application by the promisee is to be made, in such a case, it is a duty of the promisor to apply to the promisee to appoint a reasonable place for the performance of the promise and to perform it at such place. Section 49. Fifth, where the manner or the time of the performance is prescribed by promise, in such a case, the performance may be made in the manner or at the time prescribed by the promise. Section 50. Time is the essence of the contract. Sometimes the parties to the contract agree on the time for its performance and they agree to treat the time as essence of the contract. Although it will be decided by the parties or by the facts and circumstances of each case, the time is generally considered to be the essence of the contract in the following three circumstances. First, where the parties have expressly agreed to treat it as the essence of the contract. Second, where the delay operates as an injury. Third, where the nature and necessity requires to treat the time as an essence of contract. Note, if contract is not performed in time, it will be voidable at the option of aggrieved party. Reciprocal promises. According to Section 2, Clause F, promises which form either consideration or part of the consideration for each other are called reciprocal promises. They are of three types. 1. Mutual and independent promises. If promises exchanged in such a way that each party is required to perform his promise independently without waiting for the performance of other party, the promises are mutual and independent. 2. Mutual and dependent promises. Where both parties are required to perform their promises simultaneously, the promises are known as mutual and concurrent. 3. Conditional and dependent. Where the performance of the promise by one party depends upon the prior performance of the promise by the other party, the promises are said to be conditional and dependent. Rules as to performance of reciprocal promises. Rules regarding performance of reciprocal promises are as follows. First, contracts requiring simultaneous performance. No promiser need to perform his promise unless the promisee is ready and willing to perform his reciprocal promise. Section 51. Second, order of performance is fixed. Where the order of performance is fixed, they shall be performed in that order. Section 52. Third, order of performance is not fixed. Where the order of performance is not fixed, they shall be performed in the order which the nature of the transaction requires. Fourth, where person reciprocally promise, firstly, to do certain things which are legal, and secondly, under specified circumstances, to do certain other things which are illegal. The first set of promises is a contract, but the second is a void agreement. Section 57. Fifth, in the case of an alternative promise, one branch of which is legal and the other branch is illegal, the legal branch alone can be enforced. Section 58. Appropriation of payments. According to Section 59 to Section 61, following are the rules for appropriation of payments. First, on the instruction of debtor, if instructed by the debtor to appropriate for the desired due, where the debtor expressly states that the payment is to be applied to discharge a particular debt, the payment must be applied accordingly. Section 59. Second, if no instruction given by the debtor, in such a case, the creditor must appropriate the payment towards the debt to which, under the implying circumstances, the debtor intended to do so. Section 59. Third, neither instructed by debtor nor implied by circumstances. In such a case, the creditor may apply it at his discretion to any lawful debt actually due and payable to him from the debtor. It makes no difference whether the recovery of the debt is or is not barred by the law of limitation. Section 60. Fourth, application of payment where neither party appropriates. Where neither party makes any appropriation, the payment shall be applied in discharge of the debts in order of time, whether they are or are not barred by the law.